I think those of you who attended the earlier Oxford debates know what we're up to here, what we're doing. We'll have the usual affirmative and negative, and then we'll go to some questions. As the moderator, I'm going to turn to our judges, and if we have time, to the audience, and engage our judges and audience in asking the debaters questions. So hopefully that'll give all of you a chance to think about what you'd ask as you listen to the affirmative side and the negative side here. The question, of course, is written over there. The democratic system design of the United States effectively maintains checks and balances of government power. And so that's the question that will be there. We've tried to create a question that will have both an affirmative and a negative to it. Hopefully we've succeeded in that again. Let me just turn to some introductions here at this point, and let me start with our students and the debaters. From the affirmative side, would the affirmative side stand up, please? Finley doesn't read, correct? You're yes. The first affirmative? Second affirmative. And Tiziana Mena, you're the first affirmative. Okay, thank you very much. Negative? Who's the first affirmative? Okay, so Chase DeBona, right?
Yes.
You're the first negative, rather?
Yes, sir. And
Claire Mullings, you're the second negative, correct? Okay, congratulations. For those of you who've seen the earlier debates, you know getting to this point, to the final, quite skilled, so we're pleased to have it. And now let me introduce our judges, if you don't mind, and if you all would stand. I'm going to start over here on your right with Karen Francis Begay, University of Arizona, and she and I were talking a little earlier about her responsibilities. She's been at the University of Arizona how many years now? 28. I thought I knew the number, Karen. Next to her is Jackie Norton, who is the president and CEO of the Rodell Foundation. And next to her is a person I've begun to think is a friend of mine, as she and I have worked together. I hope that's the case, Michelle. Representative Michelle Udall. Next to Representative Udall on her left is Michael Polyakov, and he is the president of the American Council of Trustees and Alumni. And finally, at the end of the table is Ronnie London, Vice President for the Faculty Legal Defense Fund. What a fine set of judges we have here today. I want to thank all of our judges, and you all are scattered through the audience, and I've seen you throughout the day. The students do a great deal of work, but this wouldn't be successful without judges who come and act in an unbiased way, listen to each of the sides of this debate, and try to do so based on the skill, the presentation, the argumentation of the debaters. So I know that's what we'll do once again, is put our biases aside and judge the quality of the debate that we have here today. Okay, I think we're ready to begin. I will, as previously has been done, at the end of 6 minutes for the first affirmative and first negative, I will hold up a sign that says 1 minute left. I will not do so earlier than that, but I'll keep the time on my trusty little Apple Watch here, okay? Everybody ready? Okay.
We agree that the democratic system design of the United States effectively maintains checks and balances of governmental power. We believe the United States structures of government effectively meets this burden because it has, to a great degree, successfully respected the rights of its citizens. To further frame the ground, it is critical to compare the United States system of checks and balances to other nations in order to determine how effective it has been. The standard is not perfection, but rather evidence of relative success in protecting the rights and prosperity of its citizens. We think that the United States is not particularly fast at solving its problems, but checks and balances take time. Effective, complex solutions take time. China, for instance, is a government which reacts and assesses problems very quickly, which necessarily means lacks of checks and balances. Our first contention is that government power is successfully constrained by its legal underpinnings. Here are a few highlights of the system. To be noted, this list is by no means comprehensive. A. Bill of Rights. The Bill of Rights, along with other amendments to the Constitution, spell out Americans' rights in relation to their dwelling. It guarantees civil rights and liberties to the individual, like freedom of speech, press, and religion. It sets rules for due process of law and reserves all powers not delegated to the federal government, to the people, or to the states. B. Rights upheld by the courts. The legal system acts as a substantial and effective check on government power by protecting the rights of the citizen. Some examples of effective action on the part of the Supreme Court are as follows. Tinker versus Des Moines. The court ruled that students wearing black armbands to protest the Vietnam War was pure speech, or symbolic speech protected by the First Amendment. Brown versus Board of Education. Supreme Court upheld that segregation in schools violated the 14th Amendment. Here, the system was stress tested by Jim Crow, but checks and balances prevailed. Obergefell versus Hodgson. The Supreme Court upheld the right of same-sex couples to marry. Baker versus Carr, 1962. For the first time, the court held that the federal courts had jurisdiction to consider constitutional challenges to state legislature redistricting plans. C. Federalist system. A federalist system offers additional protections against government tyranny. In the Constitution, central and state governments received power that was shared and split in a federalist system, preventing tyranny of one over the other. Madison put forward his idea of federalism in Federalist Paper number 51. The power surrendered by the people is first divided between two distinct governments. The different governments will each control each other. At the same time, each will be controlled by itself. In the 1997 case, Prince versus United States, the Supreme Court ruled that the federal government could not command state law enforcement authorities to conduct background checks on prospective handgun purchasers. Bans of nullification count on the states to check federal tyranny. But sometimes it cuts the other way. States are also tyrannical. Indeed, if state and local governments could invalidate federal law, Virginia would have continued its ban on interracial marriages. Texas might still be jailing gay people for consensual sex. And constructive gun bans would remain in effect in Chicago and elsewhere. D. Elections. The most fundamental principle defining credible elections is that they must reflect the free expression of the will of the people. The United States elections are both fair and free. By all measures, the 2020 general election was one of the most secure elections in our history. Voters turned out in record numbers to cast their ballots by mail or in person, and the votes were counted in a timely manner, said the Department of Homeland Security, Cybersecurity, and Infrastructure Security Agency. E. The Constitution allows for modification, which builds in the possibility of productive change by future generations. This system has been utilized to correctly endow rights to previously excluded groups, for example, in the 14th and 19th Amendment. Our second contention is that the U.S. has maintained checks and balances through significant stressors to its democracy. The United States is the world's longest functioning democracy. This is a testament to its system of checks and balances and that system's ability to overcome adversity. Our nation has survived monumental shifts in political opinion, a civil war, foreign aggression, globalization, and a rapidly changing technological landscape. While our responses have not been perfect, the the system has managed to uphold many of our inalienable rights throughout. Regents Cup is an example of an effective check and balance. Free speech maintained by citizens for their benefit. We acknowledge that our system is not perfect and vow to continue improvement. However, we hope for an affirmative vote in acknowledgement of the tremendous accomplishments the U.S. system of checks and balances has achieved. Thank
you. Good evening, everyone. Before we get started, I just want to say a few thank yous. First, to the Board of Regents for setting up such a great opportunity for us to debate and celebrate civil discourse. To all of you for attending, giving us an audience to ramble on to, and as well to the judges and the moderators of this debate, as well as to our opponents and my wonderful partner, Claire Mullings, for giving us the facilities to make this debate. Now, with that being said, my partner and I are proud to negate the resolution that the democratic system design of the United States effectively maintains the checks and balances of government power. Let's begin with some definitions. The democratic system design of the United States should be meant to understand the three distinct branches of government in which Supreme Court justices are nominated and sworn in, and the president and members of the legislative branch are elected. Effectively maintains is defined as successfully continuing. And in the context of this resolution, it should be understood as upholding power balances within the government to prevent one branch from overtaking power. When addressing the maintenance of the government, we must go back to the foundation of our nation. Has our country maintained the checks and balances written in the Constitution, the same checks that were intended by our founding fathers? We contend that it hasn't. Checks and balances of government power are meant to understand the limits of controls of each individual branch of government when enforced in a consistent manner. An example of this would be when a president can veto a bill that Congress passes, but Congress can override that veto with a 2/3 majority. Now, in the context of this debate, when we're dealing with such important issues like individual rights, it's not enough for the affirmative to just give a few examples of when this system has worked. They have to prove through a pattern that this is consistently enforced and that it enhances our democracy. If the negation can prove that the checks and balances have failed to maintain the original intention and power of each branch, then we're the winners of this debate. Which brings us to our first contention, that the system of checks and balances has failed to create an effective partition between the judicial and the other two branches. The Supreme Court has become heavily politicized. This is an open secret at this point. Nominations have become decidedly partisan, and votes are almost split exactly down party lines, which removes much of the partition between the executive and legislative and the judiciary. One of our founding fathers, Alexander Hamilton, warned against this exact practice in the Federalist Papers. The importance of the papers cannot be overstated, as they provide us with a framework through which to understand the original meaning of our founding fathers. In Federalist Paper 79, Hamilton writes, "The general liberty of the people can never be endangered from the judiciary. I mean, so long as the judiciary remains truly distinct from the legislature and the executive." Considering how politicized our appointment process has become, it seems fair to say that our current political process has failed to enforce the vision of Alexander Hamilton. In addition, these decisions to block qualified nominees in the past have contradicted what people in America actually want. For example, a poll conducted by a political organization, ORC, in 2016, found that a significant majority of America wanted the Senate to hold confirmation hearings for potential Justice Merrick Garland, but the Senate still refused. If the goal of the democracy is to have the Senate and the Congress represent the will of the people, then it's failing on the front of judicial politics. However, polarization doesn't just end with the nomination process. Although judges are supposed to leave their personal politics behind, we're seeing increased polarization on the court and judicial activism. In fact, 21% of decisions since the 1970s have been at a 5-4 rate, which shows how the discrepancy between the thought of conservative and liberal justices incorporating their values into the judicial. Robert Barnes of the Washington Post claims that there's a loyalty effect in which judges who are appointed by Democrats are more likely to vote for those Democratic policies, and vice versa. The same polarization is present in day-to-day politics, and the judicial only serves to enforce that. If we create a judicial where it's simply a formality to validate the laws passed by the legislative and the executive, and we create a dangerous precedent when the judicial contradicts those values. 1830's Worcester v. Georgia decision is an extreme example of the negative effects of what can happen. When Andrew Jackson signed the Indian Removal Act, giving the federal government the power to exchange native-held land in Mississippi for the West, known as the Indian Colonization Zone, the Supreme Court struck this decision down. However, by 1836, Andrew Jackson uttered the infamous phrase, "Let them enforce it." He went past the Supreme Court because they hadn't given him the decision he wanted, and the results were catastrophic, with 3,500 Native Americans being brutally killed on the Trail of Tears. Another contention is the concerns about and within the power of the executive branch. The Brennan Center for Justice outlines the faltering protections with product that protects directors within the executive branch. Selah Law versus Consumer Financial Protection Bureau ruled that the president has absolute authority to fire or remove directors. Not only does this remove the long-time practice of structuring executive branch agencies in ways that insulate certain federal officials from undue political control, but it also proves the erosion of checks and balances within the executive branch. Another example of this is the role of the military within our current system of checks and balances. It's become a question because we've had past military involvement that was written off, like in Korea, as a military action. Congress is supposed to check the power of the president to enter into these conflicts through a vote. However, there's plenty of loopholes, as we can see, that have prevented that from happening. And the War Powers Act has only exacerbated these current problems. For these reasons, for the overreach of the executive and the failure of the partition of the judiciary, we proudly negate the resolution. Thank you.
I'm now going to turn to our judges and see if our judges have any question to either team or both teams. Judges? I'll leave it off.
Yeah, thank you. To what extent would you say that executive action and regulatory agencies reflect a strength of the checks and balance system or a deficiency?
Would the affirmative like to answer, or would you like us to first?
I think I'll probably take that first. I think that when we're thinking about checks and balances, we should be primarily thinking about between the three branches, and we should be thinking about between the states and the federal government. So I think we should refocus on that for the main topic of the debate. I think that we can acknowledge some of the flaws in the framer's logic without saying that the entire system has failed to maintain its efficiency. So I think that potentially the president might have too much power in some of these cases, but I do believe that his power is reined in by the other branches and by the states specifically, when a lot of the enforcement is actually done at the state level.
And then just to answer your question as well, not only are checks and balances eroding between the three branches, we've seen that the president had the ability to pretty much declare anything a matter of national security and override the Supreme Court in terms of issuing executive orders. We see that the president pretty much has unlimited power over our military by simply not declaring something a war. However, something that the negation actually very specifically focuses on is the erosion of checks and balances within the executive branch. There are nonpartisan positions that are ideally supposed to persevere throughout presidencies through partisan divide. However, the Supreme Court has now ruled that we can actually fire these officials. This means that we are now opening our executive branch to the whims of the political party in power. However, I just also want to go back to the burden of the debate. So, two things. First of all, the checks and balances that we have currently have extended beyond what our founding fathers have anticipated. So if we want to look at it effectively maintained, we need to look at the entire history of the United States. Our founding fathers did not write the Constitution intending for the president to basically declare anything a conflict and maintain military power without the check of Congress, without the check of the people. That is extended far beyond our founders' intents, first of all. And then second of all, we can also see that not only has the federal government failed once or twice, they have consistently failed to uphold checks and balances. We turn to Worcester v. Georgia specifically because this is not even an issue of constitutionality or even bolstering political parties, but it is a matter of life and death.
So I'd like to respond to the first part of that, nonpartisan positions. I think that it's easy for our opponents to point out specific examples of where things are politicized, but what is less apparent is in the background when things run down. It's actually really difficult being in government, I'm sure, because you only get in the news when something goes wrong. And I think a clear example of where something has stayed nonpartisan is the Fed. And I think that its importance cannot be overstated in these cases, that has not been politicized. This is still a position that has a lot of control, but is recognizing the importance of a nonpartisan approach and a long-term view for our economic success.
And I don't think we should underestimate the amount of executive orders that have been overturned and haven't been allowed to take action. And so, even though some of these checks may take more time than others and therefore still have an opportunity window to make some sort of actable effects, create some effects that maybe are not what everybody wants to see, we still have processes in place that do occur and can overturn some of those actions and create positive changes in the direction of where the American people and where their representatives want to see.
That's an interesting point. I'd like to respond to that because of the conversation around executive orders. It's one of the least well-defined areas of executive power. And I think if we can look to two high-profile executive orders that have been filed in the past 5 or so years, with President Trump's travel ban in 2017, almost immediately after he took office, and President Biden's mask mandate. Now, both of those were eventually struck down by federal courts, but they still had months to take place in which they were the law. And now afterwards, we're stipulating that this was a bad idea and that they never should have taken place in the first place. But you can't undo the damage that may have been done by those things that we're determining now are unconstitutional. So the lack of speediness in terms of executive orders does create a serious problem.
I think this goes back to one of the fundamental things about a system of checks and balances. It's easy to say, hindsight being 2020, that something should have been overturned sooner. But you have to recognize that in order for a democratic system to function properly, things have to be purposefully slow in some cases. And the one exception to this is the executive branch, because it's dealing with issues of national security, where immediate action is sometimes really important. So we have to balance those two things. And I think that both of those cases are actually really good examples for the affirmative of where we do have the system. It should move faster, but it's really important that we do the due diligence and that we allow it to go through the process of checks and balances.
I would also just like to go back to another high-profile executive order that actually ordered the internment of Japanese Americans during World War II. I understand that the affirmative is concerned about things taking time, but in these situations, sometimes people don't have time. This is a long-term internment that violated the constitutional rights, the Bill of Rights that the affirmative even states in their affirmative case. And this violation is something that, once again, time is detrimental. And I think even then, we can once again go back to Worcester v. Georgia. Checks and balances should have worked. The Supreme Court struck down his decision. But the executive branch has the ability to enforce the judicial branch, and in some cases, they choose not to enforce it. So in this situation, in the case of Worcester v. Georgia, there is no recourse. There is no hope that the Supreme Court will someday overturn this executive order, because the Supreme Court made a decision. They said it was unconstitutional, and it happened anyway. And once again, some of these matters are life and death. Sometimes we don't have time, and that's something that I think that we should, while I understand their need to balance time to have steady progress, in a very explicit situation, that is not possible.
I'm going to ask that we turn to another question. The judges, yes, President Norman.
Both teams have done a nice job about talking about checks and balances in the traditional sense of the three branches of government. And I hope this isn't a detour, but I'd be curious to hear your thoughts about the role of individual citizens in assuring that checks and balances are maintained as they should. For example, in Arizona, we have long honored the right of citizens to refer things to the ballot, and we have recently had several of those initiatives overturned by the courts. So I just generally would welcome your thoughts on the role of citizens in checks and balances.
So I think that the Arizona's, our ability to put things on the ballot, our recall and referendum, all of those processes are fabulous things. However, when Arizona attempted to enter the Union, attempted to enter the United States, we were told that we would be barred entry until we removed our referendum, we removed recall from our Constitution, because the United States found that that was unconstitutional. This was actually added later after we became an official state. So while I understand the fabulousness of Arizona in the sense that we are one of the only states that allows citizens to have direct recourse in our government, not only is this rare in terms of across our entire country, but it actually was directly in contrast with the traditional sense of the U.S. Constitution and U.S. checks and balances.
You all have a comment?
Yeah, so our burden is only to show that the democratic system design of the United States has been able to effectively maintain checks and balances of government power. And so this doesn't mean that we can't expand the ways that we effectively maintain checks and balances and create avenues to do that that may be more effective and accessible to our people. And so I don't think that just we need to adhere necessarily directly to what our founding fathers had decided were the avenues through which we could do this. And so I think this referendum is a really good way that we can start to implement some new forms of checks and balances, and it's something that should be considered.
I think that it is important to recognize that in any democratic system, citizens act as a check on the government because of the responsibility that the government holds. And in this case, it's through elections, which is one of our main points in our first contention about how we have free and fair elections. I do think that there are certain issues that citizens should be able to directly weigh in on, but I do want to recognize that we are a representative democracy, and that for many issues, I think that we elect a person to make choices for us. That person has been given a responsibility to use their good judgment in some of these cases. And so I do think that there are scenarios in which it shouldn't just be a blanket vote for the citizenry. It should be up to the good judgment of that individual that has been selected by the citizen.
And who's informed by committees that present to them experts in their fields, their opinions, and they are better informed than potentially an average citizen who could have the time and agency to inform themselves on these kinds of decisions.
And I think that that's a great point. I think that we run into some problems when trusting so much of our power to one person because of the subjective factor of it. Like when we go back to a couple discussions ago, and we were talking about elevating the executive over the other two branches in cases of national security. A lot of these terms end up being very subjective. Like for example, one of the checks on the, if we can take it back to the federal level, is that oftentimes in federal circuit court or Supreme Court decisions, when the legislative or executive is brought to heel, if they're able to provide national security as a reasoning for the actions that they take, then the Supreme Court has a history of not actually enforcing their constitutional mandate. So we do run into some of these problems when we place this much power into the hands of one person and afford them the ability to determine this very subjective issue that really affects our rights.
I think that it's important to note why we elevate that power. And I agree that in some cases it can be problematic to elevate that power, but you have to look at the risk. Because if you don't elevate that kind of power, you risk losing the democracy to a foreign power. And that would destroy all of the system of checks and balances potentially. And so while that risk is relatively small, the magnitude is so large that I think within any system of checks and balances, you do need to be able to elevate national security. And again, I don't think that we have a perfect system, but I think that that is the logic behind it. And should we ignore that logic is to our peril in many of these cases.
Judges, another question? If not, audience members, questions? raise your hand.
I've got one.
Sure, Dr. Polyakov.
Yeah, a couple of terms that are kicking around in political discourse about political polemic are legislative bench and the administrative state. Would each of the teams care to comment on those? Is this fantasy? Is it reality? Is it a threat or not?
Well, to take the first point, legislating from the bench, I would say that that is certainly reality in some cases. And in reality, we can't blame necessarily the members of the Supreme Court, but we can blame the process that put them there. If we treat the Supreme Court as a way to force through our political agenda, and we nominate justices and vote for them or vote against them based on whether or not they'll agree with the policies that we support, then it necessarily creates a sort of state where people are legislating from the bench, where we get these increased rates of judicial activism, where there's somewhat questionable. You could even make the argument that the entire doctrine of substantive due process was developed as a result of judicial activism stemming from the politicization of the court. So I would certainly say, at least for that first one, that's a very unfortunate reality that we have to deal with through these checks and balances, and it's a problem.
Does Your Honor, Benjamin?
I think there are 2 points here. First is that when someone disagrees with something the Supreme Court does, enacts some new right that they don't believe should be more, or takes something away, they often go to this kind of discredit the court. So I think we have to be a little careful when we use this kind of language. The second thing is that this many of the decisions that the Supreme Court has made has had largely positive effects for the rights of individuals in this country, especially expanding them. And you can see that in the examples that we quoted in our case. So even if this expansion of the court's power to enforce our rights is potentially unbalancing things, it's also balancing them in a certain way by giving citizens more rights. And so we would say that upholding the Bill of Rights is a very positive thing for checking the government's power to be authoritative over its population.
I'm sorry, go ahead.
And along those lines, the court's responsibility is to uphold the Bill of Rights, and it's one of their responsibilities. And these rights are surrounded with political content. So we can't ignore and expect that our court will be a completely apolitical institution, and that individuals won't have certain political leanings that they choose to represent that court in discussion, and ultimately reach a decision that represents the Bill of Rights as that upholds our rights. And so every court is political, every conversation can be political, and so I don't think that we should expect that politics is excluded from the Supreme Court.
We just want to mitigate it.
And it certainly is good.
I don't think it should.
I'm sorry. Let me ask a related question. In Federalist 78, Hamilton argues that the court is the weakest branch of government. And he goes on to talk about the means by which we have to assure strength in that court because of its weakness. So are there changes that are necessary now in light of the whole question here of balance of power, given Alexander Hamilton's considerable concern about the weakness of the court?
I just wanted to touch on something really fast regarding the last question. We were talking a lot about in terms of, I feel like theoreticals. I want to take the politics out of something really quick, and I think Roe v. Wade is a very good example of this. Roe v. Wade is considered a federal overreach. In fact, the reasoning behind it has been deemed shaky at best, and it's a very good example of judicial activism that revokes power from the states. And I think that's a great example of how the Supreme Court has overreached in that sense. But going back to your question more specifically, I think that when we look at the Supreme Court, the reason, I understand the founders' hesitancy in terms of giving the Supreme Court the ability to enforce certain decisions, because then we can see the monopoly of power coming out of that. But on the other hand, giving the Supreme Court no recourse to make sure that the executive enforces their decisions in at least some manner is extremely detrimental. So I think that some reform would be imperative on that end. But also, when we look at our amendment process, it's almost nearly impossible to pass an amendment. For example, the ERA is extremely popular. In fact, NBC Washington in 2020 found that 75% of Americans support it, yet it has never passed. So although we ideally would want to make change, realistically, that may never happen. So the checks and balances that we have, we must look at what we have now, because if we attempt to hopefully amend it maybe in the future, that day may never come.
And I just wanted to add on to that and somewhat go back to Peter 79, because I think, or excuse me, 78, because I do think that it sets an important limitation on the court. He's clearly very concerned about the separation of that branch from the others and the relative weakness while still having those protections. And I think you could argue that 1804's Marbury v. Madison is the beginning of our modern sort of view of the Supreme Court, which established the doctrine of judicial review, which greatly strengthened the power of the Supreme Court. However, conversely, as the Supreme Court gains more power, that means that the other two branches have more to benefit by getting justices who agree with them onto the court. So it's an interesting sort of paradox where the more power the Supreme Court gets, the more it opens itself up to the interference of the other two branches, which I think could be a key reason as to why Hamilton advocated so strongly for a weaker and separated from that court. So I think it's important that it's difficult to retract the doctrine of judicial review now that it's put out there. But I think that the crucial thing here is that we work more slowly to resolve a lot of these political disputes that we're having, a lot of this polarization. I think if we can have better conversations, we can get back to a point where we were all voting to confirm justices we agreed on. Antonin Scalia, I believe, was 98-0 with 2 abstaining. And that was after the point at which this had been established. People still got together and saw the potential benefit of adding them to the court. So I think general steps to reduce polarization could be a good thing for the benefit of the judiciary.
So our opponents covered a lot of ground there, and I want to take some time to unpack each of them. On the Roe v. Wade, just saying that it's an overreach, like it's a complete fact, I think that that's a little bit much. I don't think that we can look at these red declarations and just know this to be absolutely true. I'd also like to point out that the relative weakness of the Supreme Court is intentional, and I think that it is a beneficial thing in a lot of cases because it is the least accountable to the people. The lifetime appointment insulates it to a certain degree. A president can be voted out of office, a legislature can be voted out of office, but the Supreme Court, having that relatively lower power, is actually really good for the checks and balances. I think that any modification, although it is built into the Constitution, is specifically tempered because modification risks damaging the system. The reason, or at least one of the main reasons, that the United States system has lasted so long is that it takes time and substantial effort to make changes to the founding document. And therefore, that founding document is substantially more, it's taken far more seriously than just a law that's passed, right? Because it is so difficult to amend. So I think that it is actually to the United States' benefit, and part of the reason it's lasted so long, that it is very difficult to amend, but there is a process for amendment, as we point out in our contentions.
Questions? Yes, sir.
I would just wonder broadly what your view is do you think the arc of American history bends towards more governmental power, less governmental power, or does it happen in fits and starts? Yeah.
I think that's a really interesting question, and I think that's one that requires, I guess, a degree of nuance here. So when we are looking at today's debate and how that question specifically applies to our resolution, the words effectively maintains, once again, takes us back to the original powers of these branches and then how they have extended beyond that. So our federal government, even as a whole, was never intended to be as large as it was. We look at the southern states and their concerns of federal domination and how anti-federalist concerns, that's why the states have the power, that's why we have the 10th Amendment, because those powers were supposed to be promised to the states. However, then on the other hand, we also see that in cases such as Common Core, the federal government extends beyond their powers, they infringe upon the states' rights, and instead they overreach and attempt to financially incentivize states' power, or to incentivize states. So I think it's definitely a question of just balancing, I think, more of the question between the power between federal and state government. But also, I do not have the power to reshape our government at this time. But I think it's definitely just something that it depends, I think, on, it depends.
Would you like to respond?
I would agree with a lot of what she said, that the government has changed in its size and in power and how it is distributed across the different levels. And I think that these are important changes that have occurred so that we can reevaluate how we are checking and balancing our government on every level of government. And so I think that that evolution has been a mark of effective maintenance of checks and balances.
A final question to Regent Manson. Oh, sorry.
I was never searching to be back.
Oh, okay. I thought you were telling me you had a question.
Okay, fine.
I have my back to you, so I'm gonna turn around. You get the final
Oh
question.
my, no pressure here. So, in recent years, we've seen a greater use of executive order. And often the executive branch argues that it is because of lack of action by the legislative branch that necessitates this executive order. So could it be argued that the executive branch needs greater power when one branch of government fails to act and creates a void of inaction?
Yeah, of course, I'd love to. So, I think that it's certainly a very interesting issue. And I think the number of executive orders is something that's not lost upon our current political discourse. Just due to, once again, it's very loosely defined power as to what is entailed in an executive order, what's allowed, what's not allowed. You see, presidents firing them off for laundering the food. I think that. To paraphrase here from the app a little bit, sometimes the gridlock in the legislative is a little bit necessary. When there's issues of maybe a minority group, whether that be ethnic or political, a lot of the things that we have in place to prevent that from going too fast. A lot of people promote the gridlock, but I recall watching a C-SPAN speech from Antonin Scalia where he tells us that we should love the gridlock because that's actually what protects our rights in the end. So to answer that, I'd say that the executive pushing that past is giving too much power to the executive because of the fact that we don't have those systems in place to make sure that the rights are being protected.
Additionally, I think it's just worth noting that it's a very slippery slope in terms of what is considered an executive power. The negation focuses on how the executive is able to claim national security as a reason for making a lot of decisions and pretty much sidestepping Congress. The purpose of executive orders as it was adopted was to speak only in times of emergency, in times that Congress could simply not act quickly. However, now we see it as a way to simply sidestep Congress. And once again, that merely proves the failure of our own checks and balances, the fact that the executive is able to just sidestep Congress in a sense that, once again, taking away the rights of the people, taking away the representation that the people are supposed to have in terms of passing laws, in terms of passing decisions that are supposed to govern their own lives. They lose all control of that.
First, I'd like to point out that the president is recently elected to office, so I don't think people are taking away from. I'd also like to point out that perhaps one of the reasons that we've seen an increase in this kind of executive actions is that, frankly, the world moves faster today than it did even 20 years ago, and certainly faster than it did 100 years ago. Globalization and the increase of technological advancement and the speed at which things move, I think will also be an explanation for this.
Thanks very much, folks. We're going to turn to the closing arguments at this point. I'll find you
I'd like to first thank the judges and our opponents for such a friendly conversation and for the merits of their argument. I thought it was very well thought through. This being said, I believe that there is a clear path to an affirmative ballot in this round, and I'm going to go through it starting with the framing. According to our framing, which goes uncontested by the negative, we are looking at if the government is able to defend citizens' rights, and if they are able to offer them prosperity in the long run while doing this. Additionally, we are not asking for a perfect outcome. We understand that there's not going to be a perfect system. Instead, we ask for a comparison of what another system can offer versus our current system. there are always going to be trade-offs, but we truly believe that our system of checks and balances has done overall a very good job at maintaining the rights of its citizens. We show this in our first contention with subpoint A, the Bill of Rights, that is in subpoint B enforced vehemently by the Supreme Court. If you actually look at the history of what the court has done to support rights, you can put aside the judicial activism and actually look at the results. The results have been positive, and they have been iterative over time to improve and empower more people to have rights in this country. I would say that is an effective system of checks and balances working to protect our rights as citizens. And third, we talk about the federalist system, which goes largely unaddressed by the negative. This system that the United States has curtails a lot of the powers of the federal government because the states have a lot of control over how they enforce things, and they have a lot of powers themselves. And so this insulates citizens from the federal government to have these multiple levels that can fight between each other, as Madison pointed out in his papers. Fourth, we have elections, which goes uncontested by the negative. This is accountability to the citizens. It is undeniable that the United States has free elections and fair elections, which again are critical and are a crucial component of a system of checks and balances. The fact that we've had free and fair elections under a system of law for longer than just about anywhere else in the world is a testament to how effective the system has been. And finally, we have the fact that we can modify with caution. And I emphasize with caution, because this is a downside. I would love to see amendments passed for things that I care about, but I recognize that we have to respect the views of others, and we have to respect the document itself. And we can only do that if it's very difficult to amend. Otherwise, it loses the respect in the eyes of the citizens, and it loses the respect in the eyes of the government. In our contention to we point to the history of the United States. And we have not been perfect by any means. There are many stains on our record, but we have overcome these things to become better as a system over time, to grant more rights to more people, to make sure that we are improving our democracy. And that, I think, is the fundamental truth of the American story thus far. We are well positioned to continue this march towards progress. On the negative side, our opponents talk about the politicization of the Supreme Court, citing the number of 5-4 choices that have been made in the past few decades. I'd like to say that it's because the court only gets the hardest questions, rather than it is inherently political. They must grapple with the toughest topics of time, and they must do so in a way that tries to do credence to the Constitution. It's a very difficult task, but I think that they've done a good job of balancing it. Our opponents have this vision that the United States has been corrupted and it has become too politicized. I point out that similar arguments have been made in the past. Our country has gone through many rough spells of over-politicization that it has come through specifically because of the system of checks and balances that we had in place. So I would point you to history, and I would point you to the progress that we can make today and going into the future. As my partner pointed out in her opening, the Regents Cup is a testament to how citizens can come together and have a shared sense of truth and a shared sense of vision about what the country could be and the ideals we should uphold. Ultimately, that is the best check and balance that we can have, and it is supported by our current system of government. With all of this said, I truly ask you for an affirmative ballot. Thank you for your time here today.
Before we get started, I just want to say thank you to UA and NAU for joining us today at this tournament. Thank you NAU for hosting. Thank you to all of our judges for helping give us feedback, for judging these very interesting topics. And thank you for my opponents for a very engaging discussion today. So now let's get started. The negation in this debate has lost this debate has won this debate in every possible interpretation of the resolution. Our system of checks and balances has failed to control the branches of government to the Founding Fathers' original intent and in the present day. The negation is winning based on the clear failures of checks and balances within the judiciary branch, which is essentially an ineffective check on the executive. And secondly, within the executive branch, which is evident by how far its powers have expanded. It is worth noting our definition of effectively maintained, which the affirmative does not refute this entire time. And this is extremely important to this round because it gives the affirmative two burdens. One, they have not only failed to prove that we have strayed from our original intent, but they have also failed to prove the consistency of our checks and balances. And that is a very important word in today's round, consistency. Doing the right thing most of the time, that is what a government is supposed to do. But having an effective system of checks and balances is something that we are striving for. Being able to consistently make the right choices, consistently defend the rights of everyone. That is something our government has failed. So let's go, first let's review the arguments of the negation. First, we outlined how the judicial branch is not protected by the executive branch and is unable to separate itself from the polarization of politics. The confirmation process is already extremely politicized. However, these justices carry their political background into the office with them. The Supreme Court is supposed to be a nonpartisan institution, and that is something that our democracy relies on. However, we've seen, with evidence that we cite, that this isn't always true, and in fact, we see even more and more polarization within the Supreme Court, which the people actually have no check on themselves. Secondly, even if we are to ignore the partisan loyalties of the Supreme Court, it is impossible to ignore the failure of Worcester v. Georgia. The executive abused its power and did not enforce the judicial's decision. This is not a matter of a rough spell, as the affirmative calls it. Rough spells have casualties. We cannot merely ignore when one or two things don't go our way. In the case of executive orders in Japanese internment camps, those were U.S. citizens that were stripped of their rights, the same Bill of Rights that the affirmative claims that our government, our checks and balances, have effectively maintained. However, we see that that's not true. Now going on to the negation's case. First of all, they talk about the Bill of Rights. However, the USSR actually had a much more liberal version of a Bill of Rights. In fact, they actually had required no permit to protest. And secondly, they talk about who we are protecting with our Bill of Rights. But I think it's worth noting that for a long time, Native Americans were not actually considered U.S. citizens, that women and people of color could not vote. And sometimes being a citizen doesn't even matter, which is evident in the Japanese internment camps. Secondly, we go on to the judicial branch. Once again, we see a systemic failure, not only with the polarization of what is supposed to be a nonpartisan branch, but also in Worcester v. Georgia, which is a key point in today's debate. And yes, sometimes the Supreme Court makes the right decisions, but once again, those come with long delays, and they might not even be enforced at the end of the day. Third, they talk about how the state government is able to balance the federal. A really good counter to this is actually block grants, in which the federal government influences state governments in their ability to set their own drinking age. If they change it from 21, they lose the money that is promised to them by the federal government. Additionally, we can look at Common Core education, and my opponent says that my opinion on Roe v. Wade is not relevant. However, that's the reason that Roe v. Wade is so contentious now, because the rationale was weak in the first place. Now we go on to elections. Once again, not everyone in our country has had voting rights throughout our entire history. And even then, we don't actually have direct access to the presidential ballot. We have the Electoral College. And lastly, they talk about how it's a living document. Once again, the Constitution is extremely hard to amend. And we can only look to the ERA, which has 75% approval in the United States, yet has not been added to the Constitution. So I ask you again today, has the United States effectively maintained, have we consistently maintained not only our founders' interpretation, but have we done so in a way that maintains the rights of every U.S. citizen, that has protected people? Once again, in the last speech, the affirmative actually brings up a comparison. What is another country that has checks and balances like we do? However, we can only look to India, which is actually the world's biggest democracy, which maintains a very effective system of checks and balances, or even British Parliament, which has a long history of checks and balances. We ask you to separate ideology from how, in today's round, and focus on where the evidence leads us. The evidence points to a fact that we have systemically failed to protect everyone's rights consistently. And that is why it is imperative that you negate in today's round, because the affirmative, once again, has not only failed to prove that our founders' original intent was maintained, but they have also failed to prove that we are able to effectively, consistently have checks and balances on our governmental power at the federal and at the state level. Thank you.
What a super job, folks, for a final round. At 6:30, we'll gather in the lobby for the award.